Today, Professor William Shabas joins us for a discussion of the role of international law in restricting and abolishing the death penalty, with a particular focus on the ICCPR and the second optional protocol. I want to start the seminar by reading a very short bio of Bill's, and this does not in any way reflect the contribution Bill has made in international law and death penalty literature, but I'm sure almost all of you joining today know Bill or have read Bill's work, and I too have read Bill's publications when I was doing my PhD, and I remember feeling very excited meeting Bill several years later. And for some of our students who are participating today have expressed similar excitement about today's event. So I'll read the bio now. Professor William Shabas is Professor of International Law at Middlesex University in London, Emeritus Professor at Leiden University in the Netherlands, and Distinguished Visiting Faculty at the Paris School of International Affairs, Sciences Po. He is Professor Emeritus at the National University of Ireland, Galway, and Honorary Chairman of the Irish Centre for Human Rights. He's the author of more than 20 books in the fields of human rights and international criminal law, including Oxford Commentaries on the Rome Statute and the European Convention on Human Rights. Professor Shabas has prepared the quinquennial reports on the death penalty for the United Nations Secretary General. He was a member of the Sierra Leone Truth and Reconciliation Commission. And finally, Professor Shabas is an officer of the Order of Canada and a member of the Royal Irish Academy, and holds several honorary doctorates. So Bill, thank you for joining us from Paris. We've only got an hour, so I'm gonna dive straight in. And my first question is going to be about de facto abolitionists. I know you've prepared the UN quinquennial reports on the death penalty, and one of the things that the reports have tracked is the number of de facto abolitionists or abolitionists in practice. But the definition differs between the UN and the amnesty version. I think under the UN version, there's about 50 countries that are de facto. Under the amnesty definition, it's about 30. So there's sort of 20 countries of difference. So my question is, where do you stand on this definitional divide between Amnesty International and the UN definition?
Well, let me tell you, first of all, let me say how happy I am to be here. I was a visiting professor at Monash University about a dozen years ago, and I spent a very nice few weeks there lecturing at the university. Your question, first of all, let me explain what the difference is between the two methodologies. De facto abolition, of course, is a very it's a category that we recognize because it's very clear that many states stop using the death penalty before they abolish it in law. And so we need to understand that process. And we also want to know how reliable it is that a state that stops executing in practice is then going to proceed to abolish it in law. But we know that that has been the case with many, many countries, including Canada, the United Kingdom, I think Australia too. In any case, it's a feature of death penalty practice. So when the United Nations started to count this many years ago, 40 years ago, what they did was they identified states that had been 30 years without an execution and considered them to be de facto abolitionists. And then they changed that to 10 years. I think about a decade or so later, they went to a 10-year period. The difference so Amnesty and the UN both agree on that. What they're doing is counting something different, because Amnesty also wants to see some subjective manifestation from the state that they are really in some kind of a moratorium on capital punishment, that they actually have stopped executing. And so there are a certain number of the 50 states that the United Nations counts based on a purely objective standard. That is, have they not executed anybody for a decade, then you go on the UN list. But Amnesty says, no, there's an additional thing we want to check, is whether the state really believes that they've stopped executing. So both of those are useful pieces of information, I think. The thing that I did when I was preparing the UN report, actually not the most recent, but the one in 2014, was to look at how reliable it was that a state that had gone 10 years without executing, how reliable is that? Because it's an arbitrary number. You could pick 11 years, you could pick 9 years, you could pick 30 years. Each one would tell you something different. So what you want to know is, how reliable is it that a state that stopped executing people for 10 years is never going to reintroduce the death penalty and is very likely to proceed to abolition in law? And the fact is, it's very, very reliable. It's just about as reliable as it is that a state that abolishes the death penalty in law will never return to it. We know that every once in a while, states abolish it in law and they threaten to return to it, like the Philippines. So even abolishing it in law isn't it hasn't copper fastened the abolition. Still possible to go back on it in some circumstances. So I mean, I think that the UN tells us everything we need to know. That a state that's gone 10 years without executing, it's a minute chance that they will return to the death penalty. So Amnesty's additional criterion, it's of interest as well, but it actually doesn't tell you anything more, because the states that insist sometimes that they will return to the death penalty don't do it. So that's my explanation about the two approaches.
I also have a slight preference for the UN definition, and I think you wrote in one of your publications that action speaks louder than words, and that we should perhaps place less importance on these sort of subjective commitments by the state to a moratorium, which is the sort of the amnesty definition. And you also mentioned that this 10-year, it's an arbitrary, but it is a very reliable predictor for future abolition. But I'm thinking of states like Brunei, Kenya, Sri Lanka. They are categorized as de facto abolitionist states. But Brunei, for example, expanded its capital offense last year. They clearly don't come under the most serious crime definition. Kenya, Sri Lanka, they continue to hand down death sentences with over something like 3,000 plus prisoners on death row. And do you think for these states, they sort of in a way deserve that label? And are these states sort of in a way having the cake and eat it by having that sort of definition of de facto abolitionist?
You know, this business of counting states, we all do it. It's part of the sort of culture of people who work on the capital punishment issue. And we start with this very binary distinction between abolitionist states and retentionist states. But we know that in abolitionist states, there's talk about restoring the death penalty. And we know that in retentionist states, many of them have stopped executing. So they're not really neither category is very clear. The other thing that I think is extremely significant is that in retentionist states, one of the things that we see, and we can also measure, is that they generally tend to execute less and less. So the same trend we see in states abolishing the death penalty in law is also reflected in the retentionist states, most of whom are gradually reducing, or even quite dramatically reducing, the number of executions. So Amnesty International's report that came out a few months ago says that the numbers are lower than what Amnesty said for 10 years, but I think it's just they have trouble going back further and comparing figures. The dramatic figure, I thought, was the Amnesty report says that there were 450 executions last year, and that's excluding, of course, the countries for which we don't have statistics: China, Vietnam, North Korea, and Syria. But they said 450 for 2020 compared with more than 1,600 for 2015. So that's huge. That means that last year they executed 30% of the number of people who were executed in 2015. To me, that's as dramatic a finding as noting that 2 countries a year abolish the death penalty. So I guess what I'm saying is that, you know, the binary approach can be misleading. It's part of, it's part of the way we do things, and we want to measure them. But, you know, even as I say, a state that says they've abolished it in law, I mean, the states now that are threatening to restore the death penalty, Philippines and Turkey, I don't know if they're serious about it anymore, but let's take the Philippines. Not only have they abolished it, they've also ratified the second optional protocol. It's very clear that they can't do it legally, but they're threatening to do it. So it's not an impervious category. They're all steps. And, you know, even a state that's gone all the way, abolished it in law, ratified the treaty, they can threaten to restore it again. And that's what they're doing.
I was going to move on to a different question, but since you've mentioned the Philippines, maybe we can talk about the Philippines. As you know, as you said, Philippines currently labeled as an abolitionist, ratified the ICCPR, second optional protocol, but Duterte is trying to reintroduce the death penalty through domestic legislation. We actually have a question from the Commission, Human Rights Commission in the Philippines, and the question is, well, what can be done about this? What is the role and the responsibility of the international community, or more specifically, state parties to the second optional protocol in ensuring that the Philippines does not reintroduce the death penalty? What can be done?
You know, the first observation about the Philippines is it's a very weird country on the issue of the death penalty. There's no other country like it. They've abolished the death penalty twice in the last 30 years. They abolished it first in 1986 after the fall of the Marcos government, and then they reinstated it. They're about the only country in recent years that's reinstated it once, and now they're proposing to do it a second time. So it's a they're really the exception that proves the rule. That's the first observation. Yeah. The other thing is, it's very clear that by reinstating the death penalty, they will be violating their international treaty obligations. I think the message that's so important to give them, I've done talks in the Philippines and others have. I'm not the only person who said this, but I mean, there's a limit to what you can do. We're not going to propose that the US Marines invade the Philippines to prevent them from reinstalling the death penalty. What they do within their own borders, we can't control that, but we can brand them as an international outlaw. And I think that the consequence that they should understand is that people who don't respect their word, countries that don't respect their word, who've ratified a treaty and agreed to one thing and then dismiss it, can't be trusted. For the Philippines, they have a lot of international legal obligations that have nothing to do with human rights. Everything from being able to post a letter in the Philippines that's addressed to someone in Australia, that depends on international law. And if they're known as a state that ratifies a treaty and then doesn't respect it, well, this is going to make every country wary of making deals with the Philippines. Trade agreements, all kinds of issues are going to arise because nobody will trust them. So I think that's the message that we have to give out. Just it's like the way we behave with individuals. You know, somebody who is known to be a liar or not to pay their debts, you get a bad credit rating. I think what we have to say is this gives the Philippines a very, very bad credit rating. No one will give them a credit card anymore because they didn't pay a bill. It's like that.
You mentioned that Philippines is an exception, trying to reintroduce the death penalty for the second time, and that if Duterte does indeed reintroduce the death penalty, they will be an outlaw and their legitimacy would be lost. But do you think there's other consequential damage if the Philippines were to reintroduce the death penalty to sort of, for example, to the international community as a whole? Would other countries start to want to leave, or the integrity of international law? Do you think that the damage will be beyond the Philippines?
Well, we have to be vigilant, and we have to make sure that that countries are outraged about this. And that will vary from one country to another. But, I think what will be a very good sign is that if countries that still retain the death penalty object to the idea that the Philippines is violating their international obligations. The Philippines, they're grown-ups. They ratified that treaty. And they said, we're going to respect it. And now they're violating it. I'm not overly concerned that the whole system will collapse, because I think that what's driving the abolition of the death penalty, it's not that states are legally bound not to reintroduce it. It's being driven by other much broader social, philosophical, ethical, moral forces. And in the same way that countries are moving away from the death penalty, they moved away from torturing people, from burning people at the stake, from testing whether people were lying by trying to drown them. I mean, these barbaric methods of criminal justice that are from the past and don't exist anywhere anymore have all disappeared, and the death penalty is just another part of that phenomenon. So I'm not overly concerned that what the Philippines is doing is going to, that this is the the first, the crack in the wall that's going to collapse. I don't think I wouldn't be worried about that.
We have a follow-up question from the audience that to what extent do you think marking the Philippines as an outlaw will be enough to deter them? And the Philippines have crossed international lines many times, but there's not been consequences, and the EU probably unwilling or can't suspend GSP+. Do you have a response to that?
Well, no, and I don't know. I mean, the current president is totally mad, and we'll just have to hope that the wise people in the Philippines, of which there are many, will prevail. And even if a majority of people in the Philippines would like to restore the death penalty, I think a lot of them are sensible. Even those who would like to restore it are sensible enough to know that they can't do it except by violating international law, and they don't want to do that in their country. But I don't know how far this will go. We know that he's been trying to do it now for 5 years, but and it looked like he was blocked by the Senate, and now they have a new piece of legislation that was adopted only weeks ago, and they're getting cranked up again. So I can't be sure, but remember, even when they restored the death penalty 20 years ago, they executed a handful of people. Again, I don't think it's as if, the real bloodbath in the Philippines is taking place extrajudicially.
Yeah. Bill, I want to go back to more broadly speaking about the ICCPR and the second optional protocol. So for those of you who don't know, ICCPR restricts the application of the death penalty, and the second optional protocol that comes with the ICCPR abolishes it. So the ratification of the ICCPR, I think, is nearly 90%. And then the second optional protocol is around 45 to 50%. And my first question on this is the small number of countries, I think it's about 18 countries that haven't signed or ratified the ICCPR. And those 18 countries, in my head, I normally categorize them into two. First group is the small countries that in domestic legislation abolished, but just haven't ratified the ICCPR, like Bhutan, Cook Islands. And then countries, the other group is countries like Singapore, Malaysia, I'll probably put Brunei in there too, where the death penalty is still functioning, either through execution, sentencing, or expanding its capital offenses. So my first question is about Singapore, Malaysia. Both haven't ratified the ICCPR. What other sort of international mechanisms or advocacies can be effective in restricting or abolishing the death penalty for those countries?
Well, yeah, for the International Covenant on Civil and Political Rights has 173 states that have ratified it. And I totally agree with your approach to it, your analysis. There are probably, of the states that haven't ratified it, 20 odd states approximately. About half of them are very small states, island states, most of them in the Pacific, that just say, it's just technically too hard for us, too many practical details, and they often will declare that they are in agreement and that they respect the International Covenant on Civil and Political Rights. Then you have the other category of large states like Saudi Arabia, Singapore, Malaysia, China, People's Republic of China, but they haven't ratified the International Covenant on Civil and Political Rights. And for the last 12 or 13 years, we've had this marvelous new mechanism in the United Nations called the Universal Periodic Review. And that requires all member states of the United Nations to come to the Human Rights Council and report on their compliance with human rights. And so then the only people excluded from that are the states that aren't members of the United Nations, like Cook Islands and the most important, Taiwan. So they're the only way we can get at Taiwan and I'm part of this process. They have their own internal review where they bring in a kind of a group of international experts who are to review them as if they were parties to the Covenant on Civil and Political Rights. And I'm a part of that review, which is going on now. There's a panel of us who are doing it. One of the things we find when these states, like Malaysia is a good example, Malaysia comes to the Human Rights Council and they say, we don't have an obligation under the Covenant on Civil and Political Rights, but when we apply the death penalty, we respect Article 6 of the International Covenant on Civil and Political Rights. So this is a positive mechanism. And of course, it doesn't bring them into the abolitionist camp at all, but it means that they are in practice on the subject of the death penalty, subject to the same type of supervision, a similar type of supervision as the states that are parties to the Covenant on Civil and Political Rights and that haven't abolished the death penalty. You know, and one of the problems we have with our second optional protocol, which was, I mean, it was the 30th anniversary just a few days ago of its entry into force, the second optional protocol. It was done it was adopted as a way for states that had abolished the death penalty to move beyond the covenant, which allows the death penalty under certain circumstances. But we only have 89. That is about half, just about half of the states that have ratified the covenant have ratified the second optional protocol. And that's because it's largely because the abolitionist de facto states aren't ratifying it. There are a few that have, and that's one way we could increase that number. There are about 10 states that have abolished the death penalty in law, that are parties to the Covenant on Civil and Political Rights, and that haven't ratified the protocol. And they, most of them, when they question on it, they say, yes, we'll do it. I spoke on this at a meeting a few days ago, and someone in the chat said, well, I'm from Cote d'Ivoire and we're doing it. They said, we haven't done it, but they did promise to do it and they are doing it. So that number will go up pretty soon, probably to about 100 on the second additional protocol.
You've suggested in one of your publications and also now that for countries that haven't ratified the ICCPR, but they've already abolished the death penalty in their domestic legislation, let them ratify the second optional protocol without being a party to the ICCPR. And in your view, if states do enter, and if this is possible, if states enter into the second optional protocol without being a party to the ICCPR, do you think that would in some way undermine the ICCPR in a way, perhaps undermine the enjoyment and the protection of other rights in the ICCPR, like slavery or arbitrary arrest? What are your thoughts on this?
No, I don't think so. I mean, I got the idea of that. Normally, you can only ratify a protocol if you've ratified the treaty to which the protocol is attached. That's the whole point. But there are some exceptions. And one of them is in the Convention on the Rights of the Child, which has 3 protocols. And one of them, at least, allows states to ratify the protocol. It's on child sexual offenses, child pornography, and so on, even if they won't ratify the whole Convention on the Rights of the Child. It's basically allowed the United States to ratify the protocol without ratifying the convention. So if we were to do this with the second optional protocol to the Covenant on Civil and Political Rights, it might facilitate a few more states ratifying the optional protocol. It's not a big deal, but I don't think it would be in any way weakening the Covenant on Civil and Political Rights. The problem with many small states is they see, first of all, the Covenant on Civil and Political Rights is complicated. It has more than 20 articles with very detailed rights that have to be respected, and you have to report on that regularly. And for a small state with a population of 10, 15, 20,000 people, that's a big job. And they look at it and say, we can't handle all of this. And it's complicated because you have to look at exceptions to things like freedom of expression and freedom of association. The death penalty is kind of simple, really. If you've abolished it, you just ratify the covenant and you move the protocol and move on. So it would be easy to say to them, look, just do that, and you don't have to, so that their excuse that they haven't ratified the covenant doesn't get in the way of them binding themselves in international law to abolish the death penalty. But it would require an amendment to the protocol, and probably that's not going to happen. I mean, it's my idea. I'd love to see it happen, but I have lots of ideas that never go anywhere.
I now want to move on from Article 6 to Article 7 about the prohibition of torture and its relationship to Article 6. And the attractiveness of sort of framing the death penalty within torture, Article 7, is that torture is part of customary international law and it binds states even in the absence of treaty obligations. So that's the benefit, I think, is clear. But international human rights tribunals have been reluctant to take this step, mainly because the death penalty is specifically mentioned as an exception to the right to life. So where do you see this torture argument going in relation to the death penalty? Or not going?
It's one of the paradoxes of the current treaty regime. You have a covenant on civil and political rights that prevents torture, but allows the death penalty under certain circumstances. So if you were to connect somebody to electrodes and put jolts of electricity through them in order to get a confession or for some other reason, that would be torture. And that would be a violation of Article 7 of the Covenant on Civil and Political Rights, unless you turned up the current strong enough to kill them, and then that would be okay. You know, if you were to punish somebody by chopping their hand off, as happens in some parts of the world, or chopping their foot off, or some other part of their body, that would be torture. That would be or cruel, inhuman, or degrading punishment. No doubt about that. Unless you cut their head off, and then it would be okay. So to me, this is the paradox of the dealing with the death penalty, is that and it just shows us how the death penalty is itself a form of torture in one way or another. We have this constant struggle to find a humane way of executing people, but finally, there is no humane way of executing people. We do see, and it's part of the move towards abolition, the constant attempt to make the death penalty less tortureless, less painful. That's just like the same phenomenon I spoke about earlier. So logically, the death penalty has to be contrary to the prohibition of torture. But as you say, that's been carved out in the case law to some extent by judges because of the reference to the death penalty that unfortunately is in those treaties, and that is no longer, that is well out of date in terms of most of the countries. We have it in the European Convention on Human Rights as well, and we have it in the American Convention on Human Rights. So the European Court has moved pretty close to that position now. The Human Rights Committee has generally tended to go in they interpret it differently. So the way the Human Rights Committee is the body that implements and enforces the International Covenant on Civil and Political Rights, and they have tended to go with a sort of a technical reading of Article 6, Paragraph 2 of the Covenant, which says that in states that have that have not abolished the death penalty, and then they go on with all the various rules that apply, and they've used that to say that a state that's abolished the death penalty not only can't reinstate it, but can't cooperate with the country by way of extradition where they'd impose the death penalty. The European Court, on the other hand, has really moved towards saying that the death penalty has been abolished in practice within European states. Last year, according to Amnesty, there wasn't a single execution anywhere in Europe. And they've said that means that we can now look at the death penalty from the standpoint of the prohibition of torture, and it's contrary to the prohibition of torture. They're pretty much there.
Thanks, Bill. I'm conscious of the time, so I want to move on to a question on Japan, because we have a question posted from CrimeInfo, and this is actually a question that many other Japanese academics and lawyers have also raised. So this is a sort of a key question from the Japanese participants. So it's about, so Japanese government has executed individuals whose sentences have been finalized, but in some of these cases, these individuals had challenged the safety of their conviction and had pending requests to have their cases reopened. And in 2018, we had 13 executions of Omu Shinrikyo members, the ex-Doomsday cult. And out of the 13, I believe 10 had their requests for a retrial pending. So the question posted from CrimeInfo is, what does the ICCPR say on this issue regarding the execution of prisoners whose in terms of appeals, they finalized, but they still had the pending request to reopen their case?
Well, technically, it doesn't say, it doesn't answer the question, which is, I guess, the problem. And I think you can find the answer in two of the paragraphs of Article 6, either in the paragraph 2, which guarantees due process and fair trial rights, and this is part of that due process element of the implementation of the death penalty, or paragraph 4, which deals with applications for pardon and clemency and so on, which have to be respected as well. So I think it's either one or both, but it seems to me straightforward. It seems to me also just common sense that if your law provides for the exercise of a remedy, the idea that you could obstruct that remedy, which is guaranteed by law, in other words, we don't need a human rights treaty to solve this problem. It's just a simple question of interpreting your own laws. That how can you have a law that allows you to exercise a proceeding, a mechanism, if the state can, in effect, neutralize the law by executive action, by proceeding to execute somebody. And as I say, in my view, you don't even need the human rights treaties for that. That's just how law works.
There's actually a follow-up question that's been posted, and this has also been a very popular question, but I think I know your answers to this, but I'm going to ask anyway. So you've mentioned Article 6.4 and Article 6.2, one about due process, one about the finality of the judgment. And it seems Japanese lawyers want to know, so the prohibition of this execution, is it for Article 6.4 or Article 6.2? And does it matter? Does it make a difference?
You know, I think probably 6.2 is a stronger argument. Simply because it's more general in approach. The problem with 6.4, it's always the problem when you set out some specific rules. And I think you've put out on the chat the text of Article 6, paragraph 4.
Yes, I have, yes.
The more detail you go into, the more you open the door to the detail that you haven't put on the list. And that's the problem. That's always the problem when we try to codify rules in greater detail. I'm sure that if the drafters of the covenant, if someone had pointed out to them when they were drafting it, saying, well, you've made this list where you've talked about the pardon and so on and commutation, but what are you going to do of the case of someone who's applying for a retrial because of a new facts that have been discovered or some other ground? And they would have said, oh yeah, well, we'll put that in too. They would have done it if someone had pointed it out to them. So it's part of the problem of, and we see this a lot. We see it a lot in international legal drafting as well, because you get amendments that come to texts from different quarters, and people just don't think about. They think that by adding the detail, you give greater protection, but actually sometimes you weaken it. And this is a good example. So I go with 6.2.
6.2. Okay. I hope there might be some more follow-up questions from the Japanese lawyers, but we'll leave it there for now. I'm conscious of the time. I'm going to open the questions to participants, but I see one question from a student. This is the student that was so excited to join and sort of meet you virtually. I think it's a question about the direction of death penalty scholarship in international law. And I think he's asking for advice on, what are the areas in terms of researching international law, especially for early career researchers. Do you have any suggestions on directions of research that needs to be done in order to further achieve restriction and the eventual abolition of the death penalty?
The death penalty right now is largely the preserve of 20 odd countries, 20 odd countries and 20 countries that are odd. And so as it shrinks, it means that the general studies, the kind I did when I studied the international law on the death penalty for my doctoral thesis more than 30 years ago, that we don't have there. We had to generalize a lot because we had a lot of countries that had death penalty laws and death penalty practice. And over the past 25 or 30 years, that number has shrunk so much that each country has its own special circumstances. So it means that more and more you have to specialize because it's harder to draw general conclusions about the circumstances in each place. I think that there's a huge amount, again, so we're talking about a shrinking pool of countries where the death penalty exists. And at some point, we'll get to a case where there just isn't enough to study anymore. It probably won't be very long in the future. So if you've already started your PhD, that's fine. But if you're planning to do a PhD 5 or 10 years from now, you should find something other than the death penalty because it may have disappeared by then altogether. Nobody does theses any longer on, whether burning at the stake is a cruel, inhuman, or degrading treatment or punishment, because it's a medieval, it's over, it's finished. Just historians are studying it. And I guess historians will continue to be interested in the death penalty. If you want to study that historical dimension, I think there's probably a lot to deal with. In specific countries, I think there's important research. I don't know if it's enough for a doctoral thesis, but there are subjects that are of interest. The United States, I wouldn't advise people in Australia to start studying the United States. There are so many lawyers in the United States who, contributed to a very rich case law and academic scholarly material in the United States. But, last year, if it wasn't for Trump, there would have been, are we talking there was 17 executions in the United States last year, and 10 of them are something, 9 of them are attributable to that sort of frenzy, that bloody frenzy of Trump and Barr at the end of their term. And so almost nobody's getting executed in the United States now, and that's after 4 years of Trumpism. The political winds in the United States don't even seem to encourage the execution. Again, aside from this exception of Donald Trump, I think for China, there's a huge amount that could be done. Amnesty International 10 years ago stopped estimating what the number of executions was in China. And they said they stopped doing it because they thought it was wrong to encourage China or something. I think the real reason they did it is that the person who'd worked for them for many years, who did the estimates of the death penalty in China, retired. And so they weren't able to keep, they had to train somebody new to do it. And they said, no, it's too complicated. But it turns out that the number of that you can actually map the executions in China because they do get local publicity. You just need somebody who's going to focus on one area of China and actually read the newspapers and study them. I think there's a lot that could be done there and perhaps in some other countries. But as I said, it's a small subject. In last year, according to Amnesty, 450 executions, and of those, aside from China again, 5 of them accounted for like 90% of the executions. So there's just not much to study anymore.
Thanks, Bill. I'm going to move on to the next question, which is a question that was actually privately posted to me from our partner organization, Capital Punishment Justice Project, which is a Melbourne-based NGO working for the abolition of the death penalty. And as you know, in 2018, Australian government launched its strategy to not only continue to be an abolitionist state, but also to persuade other retentionist countries to move away from the death penalty. So I think CPJP as an NGO is key in making sure that Australia sticks to its strategy. And their question is about the role of state parties to the second optional protocol. And they ask, is there a way that the second optional protocol could be used, or any other instrument could be used to prevent abolitionist governments outsourcing the death penalty to retentionist states? And I think, can I just give 2 examples in relating to this? I think is the Bali 9 case where the Australian AFP tipped off the Indonesian police. It's not quite an extradition case, but they tipped off the traffickers while they were still in Indonesia. And then a more recent example, I think, is the relationship between Australia and Japan with the reciprocal access agreement. Australian government may enter into an agreement with Japan without assurance from the Japanese government that Australian military personnel won't be executed if convicted of a capital offense in Japan. So how far can we stretch the responsibility of parties that are parties to the second optional protocol? Is the question.
Yeah, well, I think you almost don't need the second optional protocol. I think the covenant is does everything that the second optional protocol does. One of the paradoxes of the legal, it's a legal curiosity, is that the ratification of the second optional protocol by states that have abolished the death penalty and that are parties to the Covenant on Civil and Political Rights is now essentially symbolic, because the Human Rights Committee has taken the view that if you've abolished the death penalty, you cannot invoke Article 6, Paragraph 2 anyway. The case law, I mean, the limits of the case law on states assisting and indirectly contributing to the death penalty goes to situations, we've had them in Europe, where it's about mutual legal assistance, providing witnesses and doing investigations that might lead to capital the crimes and the possibility of capital punishment. And we have examples of that mainly with the United States, but also with some other countries. So it's a very important part of promoting global abolition, is making the wheels of mutual legal assistance difficult to turn when states that have the death penalty are involved. Because what we hope will happen, and I believe it happens, I'm sure that when in the United States, in the Department of Justice, when people go and say, we have to stop having the death penalty, someone will say, yeah, but they murder someone, shouldn't they pay with their life? They say, look, the thing is, it's preventing us from bringing drug pushers back to the United States for trial. We're getting terrorists to be extradited, and it's hampering our efforts at creating a global legal order where serious crimes are not being committed. So I think that part is very important. I'd have to look at the details about where, whether you would go to the Human Rights Committee, whether that would be possible. It would depend on the circumstances. There are jurisdictional issues, but in terms of the substance of the instruments, both the covenant and the second optional protocol are absolutely very useful in that respect.
I'm just going to take one more question, which is a question that I received in my inbox, in my email, from Professor Shinichi Shizuka from Ryukoku University. He asks about the executions in Japan. So in Japan, death row prisoners are notified on just several hours before the execution takes place. There's no legal basis for this under Japanese law, but so it's just a matter of practice, and the government justifies this by saying that individuals, if they're given enough notice in advance, they'll become mentally unstable, and that it's actually best for the mental well-being of the prisoner that they're only notified only a couple of hours before. And the question is, does international law have any say on this? Does this amount to torture?
Well, it sounds to me like this is just a debate between between experts in human psychology, because we're talking about mental mental harm, mental punishment. And I would have thought that waking up every morning, not knowing whether that's your last day, would make it hard for you to get to sleep and would amount to a form of mental torture. The Japanese seem to want to avoid that happening to people by reserving it till the last minute. Let's just get some experts. I assume that the experts will come back and say, either way amounts to a form of torture, either way. So stop executing people. That's the way to solve this problem. But, I think there are good arguments. I mean, I think it's intriguing. I had not heard this before, that the Japanese frame it in terms of trying to behave in a decent and humane way to the people you're executing. So if that's their starting point, then that opens the door to the arguments that, well, the decent and humane way is not to go about it this way.
Yeah, I think this is the official justification the government copies and pastes for each UN Human Rights Committee report. So yes, this has been the justification, at least. Probably they haven't had to explain it domestically, but internationally, that's been the official justification.
It would be great to be able to take them to the Human Rights Committee for violating the covenant, but of course they haven't ratified the first Optional Protocol.
Yeah, exactly. This is going to be probably my last question, which is about, you've mentioned this a little bit, but which is about the future of the death penalty. And I watched your TED talk that you've done in Zurich in 2017. So I think I know the answer to this question, but my last question is, in 50 years, do you think we would have achieved total abolition of the death penalty worldwide?
Oh, yes, absolutely. And probably before that too. It's been one of the, I think, amazing developments in human rights law over the last 30, 40 years or so, is how the death penalty has largely disappeared. Hasn't, I mean, when I was growing up, country I lived in had the death penalty too. I grew up in Canada, and I can remember as a teenager learning about a teenage boy being sentenced to death in Canada for a crime he'd committed when he was 14 years old. Now, Canadian policy then was that they wouldn't execute you if the crime was committed when you were under 18, but they sentenced the guy to death. And some years later, it was proven to be a wrongful conviction, but we didn't know that at the time. But when I practiced law when I was much younger in Canada, I defended a man who had been sentenced to death as well, and then had his sentence commuted, and we had to deal with the the post-conviction issues that arose as a result of the commutation. But my children and my grandchildren have grown up in a world where there's no death penalty, of course, and we watch it. I think it's like watching the ice melting in Greenland. It's inexorable. And we're watching it, and it seems to go faster and faster. There may be a few holdouts at some point. It'll be a bit like the abolition of slavery. The real question, I think, that we need to ask ourselves is whether that's telling us something more about human rights in general. That whether it's part of a much more general phenomenon of progressive improvement and development in human rights. And, people involved in the field of human rights aren't always comfortable with thinking about this, because as activists, they're always telling people how bad things are and they have to be fixed. And so sometimes an optimistic message seems to be counterproductive. I say, well, okay, if you're campaigning for Amnesty International and you tell people how much things are improved, they say, okay, well then I think I'll take my money and I'll give it to Greenpeace or somebody instead, because you're doing such a great. The thing about the death penalty, and I can go back to my point about these numbers, these lists, these categories we have, is that it lends itself to a quantitative analysis in a way that most human rights issues don't. How would you, if someone said, has women's equality improved in the last 25 years, how would you measure that? Is there less racism today than there was 25 years ago? I don't know exactly how you'd even measure that. There was a time perhaps when you had apartheid states, and you could say, okay, now there are so many states that have apartheid type laws, and then you could say, well, they're abolished. But the death penalty enables that. And I do think that this phenomenon, it's encouraging on capital punishment, but it's telling us something more generally about human rights.
Thank you. In terms of creating indicators, I have been thinking about, as a social scientist, different indicators that measure progress towards abolition. And often you create these different variables and create an index. And we don't do that with the death penalty. So I've been toying with the idea of trying to combine different sort of these variables that achieve abolition. And we could have a whole new sort of list of countries, but that's more of an academic debate rather than one of policy. But actually, I lied. I think there's one more question posted from our participants. The question is about life imprisonment. So the participant goes, hearing the progress is a very hopeful development, but can we be satisfied with the abolition of the death penalty? What do we need to do regarding the death penalty being replaced with life imprisonment, whether it's with parole or without parole?
I mean, the first thing, I guess, although the issues are related, we do have to make sure we keep them separate. We get into a lot of harm for the anti-death penalty movement when we move into these quite distinct and separate issues about, well, what are you replacing it with? Life without parole is a cruel, inhuman, and degrading punishment. I think I don't personally believe in lengthy prison terms at all, except in the extraordinary circumstances of protecting the public from people who are very, very dangerous. And I think that we can get into all of the issues about reforming penal policy altogether. So yeah, those things, a great deal has to be done there. One of the things that's unfortunate in the human rights movement is that with the interest in international criminal justice, which has arisen, and with problems of impunity and accountability, that in one way human rights law has become more punitive than it used to be. And again, I think of an organization like Amnesty International, which has that wonderful name, Amnesty, which suggests kind of a diffidence about criminal justice and criminal prosecution. 50 years ago, human rights activists were happy to say that they were penal reformers, that they wanted to have not only humane prison conditions, but they wanted to have a lot fewer people in prison. But now we have people who get excited when they learn that someone's been sentenced to life and will never get out. I mean, a few, not very long ago, a few weeks ago, General Mladic from the war in the wars in the former Yugoslavia, who's a terrible man who committed terrible crimes, but he's an old man now, and we're sort of delighted that he's now going to spend his life and die in prison. I don't want to see anybody die in prison. So I think that we should, we definitely don't want to lose that part of how we treat people humanely. But it's that argument. I don't like to mix it with the death penalty. I want to get the death penalty out of the way. And frankly, if someone says, well, if that means life without parole, would you go along with that? Yes. If that's what it takes, that's what we have to do. We're going to have to do it in stages.
Yeah, probably have the pragmatic way that has to abolish. And then about the life imprisonment without parole, which is actually a discussion that Japanese in Japan there people are having. But I'm conscious of the time. Thank you so much for joining us, Bill. It's been a real pleasure having you. Thank you for your time. Everyone, before you go, our next seminar, our next conversation seminar is scheduled on 18th of August, and Professor Michael Ho from the University of Hong Kong will join us to discuss the situation in Singapore. So please zoom in. And we also have a seminar, we don't have a date yet, but for September, which we will focus on the Middle East and North Africa. So please stay tuned for the notification as well. Thank you very much, Bill, for joining us. And good evening, everyone.